Madam Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 9, printed in Part A of House Report number 112-73, offered by Mr. Deutch of Florida.
Pursuant to House Resolution 245, the gentleman from Florida, Mr. Deutch, and a member opposed each will control 5 minutes. The chair recognizes the gentleman from Florida.
Madam Chairman, a little more than a year ago, the BP Deepwater Horizon oil drilling vessel exploded in the Gulf of Mexico. Over several months, millions of gallons of oil were dumped into the Gulf. The oil spill caused irreparable damage to delicate ecosystems, damaged natural barriers that protect states along the Gulf of Mexico from deadly storm surge, and was devastating to local jobs and livelihoods along the Gulf Coast. Indeed, the oil spill caused significant harm to my state of Florida's environment and economy, from which we are still recovering. My amendment will have no impact on the overall bill. While I do oppose weakening the federal review process of lease applications for energy development, production, and exploration of the Gulf of Mexico, the purpose of my amendment is simply to correct an injustice to the residents of Florida and Alabama in the bill as it is written. My amendment would strike Section 202, which imposes an exclusive venue in the Fifth Circuit for civil actions relating to the leasing of federal lands in the Gulf of Mexico for energy development, production, and exploration. Under this provision, litigation relating to leases on energy development can only be filed in a district court in the Fifth Circuit. And while the Fifth Circuit includes the Gulf Coast states of Mississippi, Louisiana, and Texas, 2 states that comprise substantial Gulf coastlines, Florida and Alabama, are in the 11th Circuit. And it makes no sense that the residents of these states will have to travel to the Fifth Circuit to have their cases heard. The effect of this section would be to prevent the district courts in Florida and Alabama from considering civil cases related to the issuance of leases for energy development, production, and exploration off the coastlines of these states. Congress has no business telling courts within a state that they are prohibited from considering issues involving a lease for energy development, production, and exploration that has the potential to cause irreparable environmental and economic damage to the Gulf Coast area of that state. In addition, requiring these cases to be moved from Florida or Alabama to a state within the Fifth Circuit will cause substantial hardship for the parties involved in the litigation, substantial hardship for the witnesses who would need to testify, and would result in substantial costs. Striking this exclusive venue provision would ensure that Florida and Alabama courts could hear these cases and reach a just result that reflects the needs of that state. Section 202 does provide an exception only in cases in which there is no proper venue in a court within the 5th District. However, this exception fails to address these very serious concerns. The parties involved in litigation on leasing would first have to determine that there is no court within the 5th Circuit that would be able to consider the case. Only after determining that there was no court in the 5th Circuit, then the parties will be permitted to file in Florida or Alabama. In short, Section 202 will prohibit the courts in Florida and Alabama from considering and rendering a decision in lawsuits on leases for energy development, production, and exploration off their coasts. My amendment would strike the section. It makes no changes to the overall bill, provides a simple solution to address this bill's unwarranted restrictions on which courts will be able to review these leases should they pose a threat to the Gulf Coast area. I urge its adoption, and I reserve the balance of my time.
Gentleman reserves the balance of his time. For what purposes, gentleman from Colorado rise?
Madam Chairman, I claim time in opposition to this amendment.
Gentleman is recognized for 5 minutes.
Thank you. I yield myself such time as I may consume. In order to ensure that there is a circuit court that is familiar with the legal issues surrounding civil actions involving Gulf energy production, it is important that venue be restricted to the Fifth Circuit so that those district and appeals court judges would have the essential experience and legal precedent to fairly rule on these technical cases. For that reason, I oppose this amendment. The Fifth Circuit, as was pointed out earlier, does include Louisiana, Mississippi, and Texas, all Gulf Coast states. If various district courts and courts of appeals throughout the country were able to hear these cases, there may be a result of having no uniformity in decision-making. And judges who do not have as much expertise or background could be making vital decisions in which the energy security of our nation hangs in the balance. It is essential that there be one federal judicial circuit that understands the technical aspects of these cases, with judges who have a background in understanding offshore energy policies and practices. This will ensure that all cases are handled fairly and expeditiously and uniformly without any confusion or delay. By requiring all cases to go through the Fifth Circuit, we accomplish this important goal. For that reason, I urge a no on this amendment, and I urge my colleagues to oppose it. Thank you, and I reserve the balance of my time.
Gentleman reserves the balance of his
15
time.
seconds.
I'll yield 15
Gentleman from
seconds to
Florida.
the gentleman.
As a former
Yields his
judge
time.
and as a state and federal judge, I would urge my colleague from Colorado to understand something. Circuit judges don't, of necessity, in the area they live, have a specific specialty. A judge may go on the bench in the Fifth Circuit and have studied patent law all of his life, knowing nothing about oil.
Gentleman's time has expired. Gentleman from Florida's time has expired. Gentleman from Florida.
May I ask how much time is remaining?
Minute and a quarter remaining.
Thank you. Madam Chair, reclaiming my time. The gentleman's opposition to this amendment is premised on a very interesting and, I would respectfully suggest, a dangerous interpretation of what is our responsibility as members of this House. The gentleman spoke of the need to have uniformity of decision-making. Uniformity of decision-making. As I understand the role of the federal judiciary, the role of our court system is to provide justice. The role is not to ensure that we have the same decision in every court. My amendment simply says that if you are a judge in the state of Florida or a judge in the state of Alabama, that you are in a position just as well as a judge in Texas or these other Gulf states to make a determination about how the law should be interpreted. The idea that judges have to have a sufficient background, and that if courts throughout the country were able to hear these, we would not be able to reach a logical conclusion. The fact is, we're not asking courts throughout the country to hear these cases, Madam Chairman. We're asking the judges within the states whose coastlines would be dramatically affected and have been affected in the case of spills like the Deepwater Horizon. Madam Chairman, I would respectfully suggest that if our goal here is to seek justice, then we must seek justice in those courts where in the states that have seen the damage. I ask for the adoption of this amendment, and I yield back the balance of my time.
Gentleman's time has expired. Gentleman from Colorado.
Thank you, Madam Chairman. If the gentleman wanted to make sure that the judges of Alabama and Florida were included, then maybe the amendment should have been written that way, and I think we would have a strong point of debate, and that would be a legitimate item to discuss. However, that's not how the amendment is drafted. The amendment talks about letting in judges of the entire country, circuits of the entire country. And for that reason, I urge a no vote on this amendment. Yes, I would yield.
Gentleman yield.
Therefore, I would like to confirm, therefore, that if the language in the bill were very clear that cases for cases to be brought affecting the leasing and the exploration of oil in the Gulf, that if those cases could be brought in any of the Gulf states, including Florida and Alabama, then the bill's sponsor would not oppose this amendment?
Reclaiming my time, I would say that we would have a more legitimate issue to debate, and we could go into that. But it's too late. The amendment doesn't say that, and so that's not an option in front of us.
If the gentleman would yield?
I would yield.
So just to confirm, the gentleman's position is that, in fact, the courts in Florida and Alabama are just as well equipped to hear these cases as are the courts in Texas and the other Gulf states.
Reclaiming my time, I would say that those judges certainly would have a closeness to the situation that would be helpful, but the circuit, I believe it's the 11th Circuit, includes a number of other states that are not as situated like Alabama and Florida. So in choosing the 5th Circuit, all the states there are Gulf Coast states.
One final question, Madam Chair.
I would yield.
I would also note that while the Natural Resources Committee has acted on this bill, this provision very clearly should have been debated in the Judiciary Committee, where all of these issues could have been worked out. And it is for that reason, given what we have to work with, that I would again ask that I would ask for adoption of my amendment, which helps to bring justice and some clarity to what is otherwise a murky provision in this piece of legislation.
Well, and reclaiming my time, my understanding is that the Judiciary Committee did not have any problems with this particular revision. But having discussed all the issues around this amendment, I would urge a no vote, and I yield back the balance of my time.
Gentleman yields back. The question is on the amendment